Good morning, everyone. Welcome to our inaugural webinar series on opportunities and strategies for U.S. companies interested in selling to the Canadian government. I wanted to mention that our webinar series is brought to you in conjunction with our partners at Rhode Island Commerce, New Hampshire Aerospace Defense Export Consortium, and State of New Hampshire Business and Economic Affairs. My name is Neil Kravitz. I'm a partner at Fasken in the Corporate Finance and M&A group, and I'm co-leader of our firm's U.S. cross-border practice. I wanted to introduce our panelists and speakers for today. Marcia Mills is co-lead of Fasken's National Security Group and counsel to the firm's Procurement, International Trade, and Customs and Technology, Media and Telecommunications groups. Prior to joining Fasken, Marcia worked in both public and private sector as external and in-house counsel in defense, aerospace and security, and information technology. Most recently, as counsel to Public Services and Procurement Canada, central purchasing agent for federal departments and agencies. So she's obviously very well placed to speak on the topics today. During her tenure at PSPC, she provided strategic and legal advice for some of Canada's largest defense and major crown procurements. Faye Voight is an associate based in Fasken's Ottawa office and works closely with the firm's Procurement and International Trade and Customs group. Faye has developed an expertise in the area of government procurement, trade agreements, obligations. In addition, she maintains broad corporate and commercial practice. So with that, I'm going to welcome everybody and turn it over to Marcia.
Thank you, Neil. Welcome, everybody, and thank you for coming today. So we've got a lot to get through, so let's dive in. Michael, if I could have the next slide. Thank you. Okay, so the one key difference between how the United States procures and Canada is in the US, there's a lot of procurement that is regulated by federal statutes and very detailed regulations. In Canada, we don't do that here. For the most part, our procurement is managed through policy and directives. So we have no equivalent to the executive order process that you have in the United States. So while this gives a greater degree of flexibility in procurement, all of that flexibility can lead to a high degree of uncertainty at times. Each federal department might take its own particular approach based on their own requirements, and all of this can be significantly influenced by the level of what I would call procurement maturity that the contracting authority and the organization might have with regard to how they put together bids and contracts, how they write their specs, even how they evaluate and generally manage the process. So that's one of the most common issues that we tend to see with our clients is a degree of uncertainty about what particular process you're going to encounter. Next slide, please. So how does it work? Canada is an extremely trade agreement friendly nation. We've got 15 international, 1 national trade agreement, plus a bunch of interprovincial trade agreements, but they all have as a basic level the objective to ensure fair, open, and transparent procurement. So as a result, because of the influence of trade agreements, as we go through the presentation today, I will raise from time to time trade agreement considerations that are different than just the standard procurement considerations. So as I said, we don't have a high degree of legislative influence in the federal procurement system. It's a policy and directive driven system. However, you'll often find that because of the trade agreement influence and the federal government's approach to procurement, that in a lot of cases, the procurement process will align somewhat closely to trade agreement requirements. Internal approval processes are also grounded in policy and directives, as opposed to being subject to strict statutory or regulatory requirements. So again, you'll see a variation in application of these policies based on how the particular department might interpret them or what kind of approval process a particular department is subject to. So could we have the next slide, please? Unlike in the United States, where we have the FARs and DFARs, in Canada, we have one set of regulations known as the government contract regulations, and I'll call them the GCRs. These are really high level regulations, and we don't have regulations specific to contract management. In the normal course, there's 4 main exclusions from competition. So if your procurement isn't covered by a trade agreement and isn't required to be competed, the regulations only provide 4 exceptions. The first one is based on purely objective, the financial cost of the contract, but the thresholds are really, really low. So goods contracts below $25,000, service contracts below 40, and in certain construction services contracts, it'd be a threshold of $100,000. So it's low. The other exceptions are more objective. So if there's a pressing emergency and any delay caused by a competitive process would be injurious to the public interest, or it's not in the public interest to solicit bids for the kind of work that the government needs done, or there's only one person capable of performing the contract. So the second exclusion, the pressing emergency, that's the one that we probably saw applied most often during the pandemic. And the other exclusion, for example, only one person capable of performing the contract, that would normally apply to a scenario where the contractor who's currently engaged by the government owns all of the intellectual property. They haven't granted licenses to any other party to use that intellectual property. And so the contract would just be re-awarded to them. So aside from the trade agreements, the policy and the GCRs in Canada, even if a trade agreement doesn't apply, we do have a common law body of law that imposes obligations of fairness and equity in the procurement process under certain conditions. So federally, the vast majority of procurements and all the defense procurements for goods above a certain threshold are going to be conducted by the Minister of Public Works and Government Services, currently referred to as the Minister of Public Services and Procurement Canada, or as you'll probably hear me refer to that minister today, PSPC. The reason why this minister has 2 names, just as some background in case you notice this, is because PSPC's statutory legal name is still Public Works and Government Services, but when the Liberal government came into power in 2015, they gave several departments what I'd call, quote, working title names, but they didn't change their name in the legislation. So it can be a bit confusing because you'll see that your legal agreements with the department will keep the legal name. So your contract will say Public Works and Government Services Canada, but the website, the marketing materials, and some of the public servants' email addresses might be defaulting to PSPC. So in this presentation, I'll apologize in advance. I'll probably wander between Public Works, PSPC, because I'm so used to using the old reference term from when I was in the government. The other department that is responsible for a vast part of the procurement is Shared Services Canada, or SSC. They're responsible for purchasing government IT services. They haven't changed their name as yet. However, this department doesn't have a specific minister under the legislation that created the department. So the minister responsible for shared services is appointed by Parliament. So up until 2019, it was the minister of PSPC, but it's now the minister for digital government that's responsible. In any event, each of these ministers is empowered by their own legislation to procure goods and services. And sometimes you can see this referred to as what's called a statutory monopoly, because in both cases, they have a wide scope of authority to buy, to the exclusion of other ministers for other departments. As between them, PSPC it's been in existence longer. It's got the most robust procurement policies and terms, and it tends to apply them relatively consistently. However, as I mentioned before, because the procurement process is based on policies, they can change during the life of a contract, and they're also subject to individual interpretation. The other thing to take note of is there's no singular location provided for all of the policies that can apply to a procurement. You can find them logged at PSPC's website. If it's a policy that's created by Treasury Board, then it will be located at the Treasury Board website. And for those of you who are going to be in part 2, one of the policies that will be relevant to you on Thursday is the Industrial, Technological, and Benefits Policy. And that one, for example, is at the website of the Minister of Innovation, Science, and Economic Development, or ISED. And shared services, being a newer department, hasn't yet promulgated a lot of fundamental policies and terms and conditions that it applies to contracts. And I haven't noticed that they're inclined to start doing that in the future. Next slide, please. So there's a couple of things to keep in mind. We're seeing an increasing use of pre-qualification processes, or what are called conditions for participation, in the federal procurement. This is obviously useful to improve the efficiency of the procurement process for both government and industry, because it cuts down on the number of bids that have to be eventually evaluated. And it also prevents bidders from putting in time, resources, and energy to prepare for a bid submission when they may not have been able to qualify to win the contract in any event. So oftentimes the pre-qualification process, like in other jurisdictions, is used to down select the bidder, either in advance of release of an actual solicitation document, so prior to the RFP, or as the first phase of an RFP process. Typically in pre-qualification, you're going to see the government looking for specific bidder or technology requirements that are mandatory. So they're the requirements that are yes, no, either you meet it or you don't. Or they'll be looking for your ability to achieve security clearances. If it's a defense contract, registration in the controlled goods program, passing a supply chain integrity assessment, and generally, if there are elements of financial or corporate strength or your actual capacity to do the work, those might also be a pre-qualification requirement. The one note I'll make is if you have a procurement that is subject to trade agreement coverage, the rules about what you can pre-qualify bidders on are more prescriptive. And those rules under the trade agreements are to ensure that someone isn't trying to design a procurement to be overly restrictive to unfairly limit competition. So while we have pre-qualification processes, which are requirements that must be met to participate, even in Canada or in other jurisdictions, you're probably also always going to find grounds for exclusion, which are conditions that, if they exist, will likely result in a bidder being disqualified from competition. And that can occur even if you're otherwise capable of meeting the pre-qualification requirements or your bid's otherwise in full compliance with the terms of the solicitation. These types of exclusions are usually the ones that address issues of fundamental legislative or policy importance that would prevent any public entity, such as the federal government or any other government, from entering into a contract with a bidder. And they're usually things along the lines of criminal conviction, fraud, bankruptcy, repeated material performance failures, particularly conflict of interest or evidence of collusion. So what's important to remember about grounds for exclusion is they tend to follow you into your contract. So they will become terms of an awarded contract, which means in the event there's a breach, for example, if you are bankrupt, if you are convicted of collusion, that will entitle the contracting authority to terminate your contract. So those grounds for exclusion usually remain what we call evergreen. So let's go to the next slide. So again, in Canadian federal procurement, probably not a lot of variation from what you see in other jurisdictions. In order to have your bid considered, there's three fundamentals. You have to submit your bid in the form and manner required. You have to submit it to the entity identified in the solicitation, and you have to submit it before the close of the solicitation period. So whether the tender is subject to trade agreements or not, under Canadian procurement law, the bidder bears the responsibility to ensure they understand the requirements and to submit a responsive bid for the tender. Really important to remember. In this light, federal procurements typically permit bidders to submit clarification questions during a question and answer period that will be held before final bids must be submitted. One thing I always remind my clients of is the Q&A period is always shorter than the bid solicitation period, because one frequent error I tend to see when I was working in the federal government and since is that bidders don't always pay attention to when the Q&A period ends, and they'll miss the opportunity to submit a clarification question, because federally, once the Q&A period closes, the government is no longer under any particular obligation to respond to questions. They may, but at that point, it's entirely discretionary. The reason why the Q&A is so important, we're going to talk about bid disputes in a minute and how to deal with when you didn't win the bid. But it's really important that if your bid requirements are unclear, or your bid team is starting to try and make assumptions about what they think a requirement means, then that's when you need to submit your clarification questions. Even though, if a tender requirement is vague or unclear and you're having a bid dispute, it may give you a certain degree of argument and leverage at that point, but it hasn't shifted the responsibility that all bidders hold to ensure that they clearly understand the requirements. The other reason why it's really important to deal with the Q&A period is that once the bid is submitted and the solicitation period closes, you can't correct bid errors. Unless it's federally, it might be a minor variation that doesn't go to the substantive importance of the bid. So for example, a missing line item or maybe a signature on a document, or the solicitation might allow certain corrections. However, even in those cases at the federal level, the ability to correct the essential or mandatory requirements of your bid, if you've missed them, it's lost after you've submitted your bid. We can just have the next slide, please. So in an attempt to prevent bids from being needlessly disqualified, in 2012, we started implementing a two-phase evaluation process. This began in the defense contracts, but it is being applied beyond defense now. And it was particularly important in defense because oftentimes in a complex defense procurement, you might only have 2 or 3 bidders. So if you end up with a bidder who's been eliminated on a technicality, you've just basically cut your bid pool down, in half, which might leave you with 1 bidder. So the two-phase selection process, it's not as in-depth as stage 1 that is done in US tendering. But what it is, it's an initial non-binding bid review that's conducted before the close of the solicitation period, as I said, and it's for mandatory requirement compliance. So what you will get as a bidder is a limited scope report that's just basically identifying which mandatory requirement you didn't meet. The government doesn't give you any information, and they're definitely not going to tell you how to make sure you meet the mandatory requirement, but it does identify to you that you've missed it. So you still hold the obligation to figure out what it is you didn't do for that mandatory requirement, and then you need to adjust your bid and still submit it within the solicitation period. The next slide, please. Okay, evaluation and selection. So we've got your bid in. The evaluations tend to follow a very typical path, probably similar to other jurisdictions. First, they're going to look at the mandatory requirements to see if you met them. This is for purposes of efficiency, because if you evaluate a bid and then at the end you evaluate the mandatory requirements, you've gone through that whole process of a bid evaluation when ultimately your bidder is disqualified. Again, keep in mind that even if within your tender documents, the procuring entity has reserved a right to waive non-compliant bids or non-compliance in bids at the federal level, this is not going to extend to a mandatory requirement, unless again, it's something like a minor error in form. If a bid meets all the mandatory requirements, then we'll move on to the scored elements or the non-mandatory elements. And oftentimes federally, the financial bid will be evaluated last. And that's to prevent a risk of influence or bias in the evaluation of the technical requirements. In most federal procurements, you're going to see a requirement that the financial bid is submitted separately, and that's done in order to prevent inadvertent tainting of the technical portion of the evaluation. If that is a requirement of your bid, it is mandatory. So again, please ensure that when you're submitting financial data with regard to a solicitation, that it remains only in your financial bid, or if you've been directed to included in a different part of the bid, make sure you're paying attention to what financial data you're to be putting into that part of the bid. Now, procuring entities usually reserve a right to seek clarification from bidders with respect to their bids following final bid submission. However, this isn't a fix-all situation. It's important to keep in mind a couple of critical points. First, don't rely on it. This is a discretionary right that the procurement authority may or may not exercise. So they're not obligated, even if your bid is unclear, they are not legally obligated to seek out a clarification. Second, it's a limited scope event. It's intended to address issues like, for example, if an evaluator can't find the information that they need to evaluate your bid, they may send you a question and just ask you to redirect them to where in your bid the information is already housed. So if you've left something out of your bid, this process doesn't let you add it in or add new information, because that's typically considered bid repair and not permissible. So in other words, once your solicitation period is over, the chance to understand what the government wanted and to make sure your bid responds to that is done. Usually the way in which bids are determined is going to be, or the winning bid is determined, is going to be in the solicitation document itself. Again, read that, ensure that you understand, how am I going to win this contract? If it's not clear, these are also questions you should be asking on clarification. Normally, once a winning bid's selected, if the procurement was publicly released as a solicitation, then the contract award notice will be posted, and that's a requirement under trade agreements. If you didn't win, you'll receive a regret letter. Most times that's going to be an email these days. The only time you may not see a bid award posted is if there's a national security related issue or a severe or a significant confidentiality issue. So what happens if you didn't win? Let's go to the next slide, Michael. Debriefing. So under the trade agreements, all procuring entities are subject to the requirement to provide a debrief. This can be verbally or in writing. Usually federally, your initial debrief is by way of letter. I've had some clients receive very clear debriefing letters, others not so much. So it's purely up to the procuring authority as to how much information they give. What they will not disclose in the debriefing, whether it's in writing or orally, is how the other bidders made out on their evaluation. So they won't disclose to you the evaluation report on that other bidder, other than obviously the winning score. Also keep in mind that the time period within which you have to request a debrief will be quite short, so you need to pay attention to that. And there's two reasons why debriefs are important. Obviously, if you lost, you want to know why you lost. You want to figure out, was this something I misinterpreted, misunderstood, or completely missed in the bid? Or does this look like it's an evaluation error on the part of the evaluator? Or did they impose some kind of undisclosed evaluation criteria to come to the decision that they came to? So those are important things if you want to protest the bid. But if you won, it's also important, figure out in the areas where you succeeded, great, but also try and make sure that you understand where you lost points and why. Particularly important for those of you who bid into the same requirements often is you might have won this particular round, but the next requirement, if you respond in the same way, you might lose points and you may not win the next time. So always important. So how do we do bid protests? If we can move on to the next slide. Okay, so there's three. Well, the way I describe it is three. There's either informally through the contract authority or through a government relations approach. And Andrew House is going to be talking about the importance of government relations in part 2 on Thursday. Formally, you can go through non-legal, what I call non-legal routes or non-judicial routes, which is through the Procurement Ombudsman or the Canadian International Trade Tribunal, or you can bring a legal action in court. We'll go to the next slide, please. So as I said, the first step in a bid protest is submitting the protest to the contracting authority responsible for the procurement. Again, that individual is identified in the RFP. In Canada, there's no official agency within the government that's going to handle an informal protest, and there's no specific document or form that you have to be filling out. However, having said that, the timing, as I said before, is important, and the content of an objection can significantly impact the success of a formal complaint later. This is because if the procurement is covered by a trade agreement, there are short time frames for submitting a complaint to the Canadian International Trade Tribunal that hears procurement disputes covered by trade agreements in order for it to be heard. But understand that the government is under no time period within which they have to respond to your complaint. However, a lack of response doesn't necessarily extend the time frame within which you need to submit a formal complaint. The content of the objection is critical. All known grounds of your objection need to be included, and this may require you to engage someone more conversant in procurement law who can pick out those necessary legal elements or those necessary comments with regard to, say, for example, an undisclosed evaluation criteria, so you can get it into your objection. It's also practical because if you submit a vague complaint about why you lost the bid, it doesn't really give the government much to work from to figure out what your complaint is about. Also, if you end up at the CITT will consider your initial informal objection, and they could refuse to consider any grounds in your formal complaint if you decide to file one, if they determine that you knew or reasonably ought to have known that you had those complaints at the informal complaint stage, but didn't raise them. Again, as I mentioned, that aside from submitting complaints, there are the other government relations routes that you might take. However, this is a more strategic approach, and you also need to ensure you're in compliance with Canada's Lobbying Act. And as I said, Andrew will be talking about that in part 2. As far as cost, this is really a relative costing factor, deciding on whether you draft your informal complaint internally or you use external advisors. Next slide, please. So as I mentioned, in Canada, our formal complaints process isn't as well structured as in the US. So we don't have the equivalent of the Government Accountability Office, Court of Federal Claims, or the Contract Disputes Act. I just did want to mention for the Canadian companies that are on the line, the Procurement Ombudsman is available, but they are available for disputes at very low threshold amounts. So it's $105,700 for goods contracts and for services, and for goods contracts, it's contracts below $26,400. So it's really low. And again, the Procurement Ombudsman is only available to Canadian companies. And if we could have the next slide, please. As I mentioned, if your procurement is covered by trade agreements, you would be able to bring a complaint to the Canadian International Trade Tribunal. And this is the only expert tribunal for procurement-specific complaints regarding federal government procurement. So if you're a US-based bidder, we'll mention this, and Faye will be discussing this on Thursday as well, but your ground of complaint would be in the World Trade Organization Agreement on Government Procurement, or the WTO AGP or the AGP. Canada is not a signatory to the USMCA that came into effect in July, and accordingly, as a US bidder, you can't raise that procurement complaint under the USMCA. So the complaints process, though, regardless of which trade agreement you're making a complaint under, it is the same. We don't have a lot of time to get into the basic nitty-gritty of a CITT complaint, but I'll just go over a couple of high-level points. First, as I mentioned, the strategic and practical impact of a properly made objection to the government department is critical if you're making a complaint to the CITT, because they will look at what your objection was at the informal stage to determine whether you knew or reasonably ought to have known you had a ground of complaint. Also, again, timing is everything, because once your complaint is refused by the government department, you have 10 days in order to submit a complaint to the CITT, and 10 days is very short. Also keep in mind that even if you have a debriefing scheduled with the government, any information or exchanges, phone calls between you and the government in advance of the debrief can start that 10-day time clock with the CITT if the government's response to you can be considered what's known as a denial of relief. So for example, if the contracting authority has told you, this is our decision, we're not changing your mind, we disqualified you for this issue, but they say, okay, we'll talk to you again in the future, we're willing to have further discussions with you, those discussions likely won't extend your 10-day time limit. Also keep in mind that this denial of relief doesn't have to be formal. It doesn't have to be in writing or provided on official letterhead. And if you've had a debrief, the CITT may determine from the facts surrounding the debrief that the time clock on the 10-day period already started. I always give a caution. Bidders who attempt to extend the limitation period with ongoing meetings and letter writing campaigns when it's obvious that the basis of the complaint was already known don't tend to fare very well with the CITT. As far as decision making, it's fast. The CITT has a statutory obligation to render a decision with 90 to 135 days after the complaint is filed. And again, costs will be dependent on how much external advisors you bring in on the issue. Could we have the next slide, please? So the other alternative is what I call a formal legal through the courts process. You would either seek a judicial review of the administrative decision at the federal court. So you don't agree with the decision, you want the court to award it, to review it, or you seek a general claim for damages. An application for judicial review has a short time frame as well. It must be submitted within 30 days from that same element when you knew or reasonably ought to have known you had a complaint. But keep in mind, judicial review processes are just that. It's a review of the administrative decision-making process, and damages are not awarded. If you're seeking damages, then you would need to bring a claim in the applicable court. Oftentimes federally, the default law is Ontario, so the statute of limitations in Ontario is 2 years. But again, you always need to be cognizant of the jurisdiction under which your particular tender opportunity has been run, and be aware of what the statute of limitations period is there. Canada can sue and be sued under Canada's legal system, subject to certain limitations, and they can be found liable for claims such as breach of contract or damages. In our estimation, the costs on JRs or court actions are probably similar to the costs you would incur in the US. Next slide, please. A couple of things to contrast for Canadian post-award modifications as far as the federal government is concerned. In Canada, the awarded contract is subject to common law. So like I said earlier, not a lot of regulatory or statutory influence here. The government doesn't hold any inherent right at law to invoke contract changes. And as I said, we do not have an equivalent to the executive ordering authority in the US. Generally, trying to renegotiate your contract post-award is going to be limited to non-existent if it was done through a competitive process, because you're deemed to have determined what your risks and what your opportunities were and to have bid accordingly. The likelihood of renegotiating scope or price is low unless there's a compelling reason to do so. So if you go in with a low bid in hopes of winning the opportunity, keep in mind that that is probably the price that you're going to have to stick to. The government does reserve the right to audit and offset amounts that it might owe to a contractor under one contract against monies the contractor may owe to Canada under others. But we don't have, as I said, the equivalent to a False Claims Act process. Those of you working on defense contracts, be aware that the Defense Production Act does give a more stringent audit capability to the Minister of PSPC and does permit pricing adjustments as of right to the government following an audit. In those cases, if those pricing adjustments are invoked, your only recourse is to the courts for review. Contract assignments are permissible in Canada, but they have to be approved in advance, and the original contractor will remain liable. Next slide, please. So there's two federal programs that we thought would be of interest to raise today. I'll talk about the Supply Chain Integrity Assessment, and Faye will talk about the Contractor Security Program. Both of these programs can impact whether a bid is accepted or a contract is awarded, and breach of either of these program requirements can result in a contract termination. So again, although we don't necessarily contract by regulation or statute, we do include these type of programs, and they are included in your contract by reference, so they become part of your contract. Next slide, please. So the Supply Chain Integrity Assessment, as you probably can tell from the name, it's conducted to determine what, if any, potential security risk could arise in procurements when a supply chain is involved. So it's looking at you and down through your supply chain to your part suppliers and underlying OEMs. Supply chain integrity assessments are not a one-time event, so the government doesn't do it. It's not a one and done. It can be required at any point in time during the life of a procurement, during the life of a contract. And depending on what's being acquired, it can also form part of the pre-qualification process, as I mentioned earlier. And if you're required to have a security clearance as a government contractor, a supply chain integrity assessment can actually influence whether you get a security clearance. As I said, even if you didn't have to have a supply chain integrity assessment during the contract, it could come post-contract if the government determines they have a security or potential security risk that's in existence or evolving. Now, if a risk is identified, mitigation measures may be required. So the way it usually goes is if a risk is identified during the procurement process, the bidder will be given one opportunity to meet the mitigation measures imposed, and if they fail to meet them, the bid's disqualified. If this happens during the life of the contract, the same thing happens. Although if you fail to meet the measures imposed, then you're deemed to be in contract default, and the government can terminate your contract at that point. So what I will do now is I will hand off the discussion of the Contract Security Program to Faye.
Thank you, Marcia. Now, as Marcia mentioned, I will be speaking about the Contract Security Program, which is a program that can impact whether your bid is ultimately accepted and whether you remain in compliance with the contract over the course of the contract. And specifically, it's the program through which Canadian contractors obtain the clearance required to access sensitive government information under those government contracts. Perfect, on to the next slide already, so that's good. One back, sorry about that. Thank you. This program is similar to that of the National Industrial Security Program run by the DCSA in the United States. And I reference this because, as I just mentioned, the Contract Security Program, which I may refer to as the CSP throughout this presentation, it only screens Canadian contractors, not US contractors. And I will explain in a couple slides more of the specifics about how a US contractor can obtain approval and clearance to work on Canadian contracts. Regardless of if you're a Canadian or American contractor, though, it's important that if you're bidding on a Canadian contract or considering bidding, that you understand the Contract Security Program. This is because a failure to obtain your clearance can result in disqualification from the bidding process. And additionally, if after you win a contract, you subsequently lose the clearance, that can result in contract default. Next slide, please. Thank you. So this slide here is a bit of a basic glossary that you can refer to throughout the course of the presentation, but also as a reference for after this presentation if you're bidding on a contract. It provides the equivalent contract or equivalent term between that's used in the US versus Canada. And as you'll see, there's, as with any government program, there's a good number of acronyms, but there's also quite a few similarities between the terms used. However, it's still important to know what exactly they are because there's always intricacies. However, one difference I will point out is that while both Canada and the US use the terms top secret, secret, and confidential, in Canada, these three terms are often referred to collectively as classified information. Next slide, please. As I mentioned earlier, the contract security program only clears Canadian contractors. So you might be wondering how a US company can obtain clearance to bid on a Canadian contract. So the answer is you rely on your DCSA clearance. What happens is the contract security program and the DCSA will work together, and the contract security program will rely on your US clearance on an equivalent basis. So if you have top secret clearance in the US and the contract security program deems that to be equivalent to Canada's top secret, they will accept that clearance. Another alternative is if you are a company in the US and you do not already have clearance in the US, but say you do have a subsidiary in Canada, you could in that case instruct your Canadian subsidiary to proceed with the bidding process, obtain its clearance, and perform the contract. So you use it as an extension of you. Next slide, please. So how do you get your Canadian clearance? There's three key steps. First, you must find someone to sponsor your organization into the program. So those entities that are capable of sponsoring you into the program include procurement officers with the Government of Canada and private organizations that are already sponsored under the, or already cleared under the program. It's key to know though that you cannot enter the program without a sponsor. Second step is obtaining facility clearance. This is really, facility implies the use of a physical location, but really at this step is when your organization, the corporation, is cleared. The third and final step is to clear individuals. This is referred to as personnel clearance. And I know that you cannot obtain in personnel clearance before you have obtained your facility clearance. And not every employee within that cleared organization needs to be cleared. It's only those that will actually access the sensitive information under the contract. Next slide, please. So while the idea that there's only 3 steps may seem like this process is quite simple, we often see companies run into issues and complications when deciding who they need to clear under the program. So the rule of thumb is that whatever entity is bidding on the contract must be cleared. However, some confusion can arise. We often see confusions among our clients in this area when there are a group of related companies. So say there is a Canadian subsidiary and a US parent. If the Canadian subsidiary is bidding, then that entity must be cleared. Additionally, any entity that's going to perform work under the contract must be cleared. So if the Canadian company is bidding, but it's the US company doing the work, then the US company must be cleared. This also includes subcontractors outside of that related company context. Next slide, please. A second consideration in the area of who to clear is your employees. So what employees actually need to be cleared and obtain their personnel clearance, because it's not every employee in that cleared organization. The only ones that need to obtain clearance are those that the contract specifies must be cleared, if applicable, and those employees that must access secure information in order to complete their work under the contract. Additionally, as this actually occurs as part of the facility clearance, but has to do with individuals, you must identify a key security officer, a chief security officer, and 2 alternate chief security officers. All of these individuals must be cleared. And I note on this point that a key security officer does not need to be a Canadian citizen. Therefore, when you're dealing with a group of related companies, and one of those companies is a US company that has its clearance in the States, you can use your same facility security officer and submit them as your key security officer for the Canadian facility. Finally, I note that any visitors must be cleared. So if, for example, the CEO of the American related company wants to come see the work that the Canadian company is performing under contract and maybe perform an audit, that CEO would require clearance from the contract security program in order to do so. Next slide, please. So another area where there's some uncertainty about what to do is when you should start obtaining your clearance. So the advice we give our clients is to start working on this and thinking about this as early as you can. This is because while it's not a rule, we are seeing a trend that the Canadian government is requiring clearances to be obtained prior to the contract award. However, the rule is that clearance must be obtained before secure information is received as part of the contract. So the tricky piece here is that to obtain clearance, you must provide evidence of a need to access sensitive information. And this creates a bit of a chicken and the egg situation, because if you don't have a contract yet, you don't really have a need for the information. So that's why this is an important step to think about early, is who will sponsor you and how to gain their buy-in to that sponsorship. So it might involve some networking and outreach and potentially government relations work. Now, finally, the reason to start this process as early as possible is it's a lengthy process. Prior to COVID, the normal processing time for clearance was about 6 months. And we are also aware of delays due to COVID-19. A lot of the government workers are working remotely. And I've also included in this slide a link to the government website that provides status updates relating to COVID. So at this time, we just know that there are some delays. If you are bidding on a Canadian contract, you may want to check out this link to see if there's any further information that's being provided. And with that, I will hand it back to Marcia, and I hope that provided you with some food for thought when you're considering bidding on a Canadian government contract.
Thanks, Faye. I will note that in part 2, we are going to be talking a little bit in greater depth about some of the COVID influence in federal procurement. And as Faye noted, the contract security program is one of those programs that's been impacted. All right, so let's go to the next slide. We're going to talk about a couple of policies today. The Vendor Performance Corrective Measures Policy, which is a huge long name. I'm going to call it the Vendor Performance Policy, the Integrity and Suspension Policy, and then on Thursday in part 2, we're going to talk about the Industrial Technological Benefits Policy. All kinds of tongue twisters there. Next slide, please, Michael. So, as I said, pretty long handle of a name, formerly known as the Vendor Performance Policy, and that's what I'm probably going to call it. This applies to most PSPC contracts. It's a contractor management policy that's intended to mitigate against procurement risks in contracts. The review looks at issues such as timeliness of delivery, quality of product, other parameters that are deemed important. So unfortunately, well, first I'll say this one is incorporated by reference into the PSPC contracts. So through the SAC clauses, which we'll talk about shortly, this policy does get brought into your contract. So it is a policy, but it becomes a contractual matter because it applies. There's nothing publicly available right now as to how this policy is being applied. So it isn't entirely clear what the outcomes are with regard to this performance corrective measures policy. However, next slide, please. According to the policy, this one has a practical impact for a contractor because it can impact your current and future contracting opportunities. Because the Canadian government tends to, and the reason why I mention this is because the Canadian government tends to implement contracts with irrevocable option periods. So even if the project might be executed or the work might be required over, say, 5 years, the term of the contract will often be a 3-year term with 2 irrevocable 1-year options. So they'll still get to the 5-year period, they'll just do it in a different way. This policy provides it as and where this matters is because this policy provides that if a vendor is subject to a performance correction measure under this policy, the contract can't be extended through the exercise of an option or through an amendment unless there's insufficient time to recompete or there's another exceptional circumstance that existed. Under this policy, a contractor could be debarred from contracting for up to 6 years. Or additional conditions could be imposed on contractors as part of the performance management process. For example, there might be more frequent reporting requirements, there might be site inspections, there might be audits. If a performance management has been required, the policy says it will remain on the vendor's file for up to 6 years. Now, one thing to keep in mind, again, with regard to trade agreements, this policy exists, but if you have a vendor performance management policy in place, it's still important because the ability to exclude a vendor from bidding on procurement opportunities under trade agreement covered tenders is tempered by a requirement that to ban a bidder from bidding, so to debar a bidder on the basis of performance, there has to be evidence of significant or persistent deficiencies in performance of a substantive requirement or obligation. So if you have had this policy brought against you, it's important to appreciate if you are being told you've been debarred from bidding, keeping in mind that for trade agreement procurements, there are specific criteria that have to be met, and considering whether you want to challenge your debarment on that basis. Next slide, please. The integrity and suspension policy. So this differs from the vendor performance policy because it's not intended to manage a contractor. Its overarching objective is to reduce the instances in which PSPC enters into contracts with entities that may have been convicted of or charged with specifically identified offenses. So the policy itself does outline what those offenses are. It was first implemented in 2015, but it's in a constant state of evolution. And when it evolves, you actually see significant amendments and changes. So we need to keep an eye on how this policy is evolving. Again, it's implemented into the contract. And in addition, bidders are required to provide certifications under this policy in order to be eligible to submit a bid. And these certifications, just like the conditions for participation in bidding, remain evergreen and they carry through into your contract if you win. So what is also important to note under this policy is it applies not only to you, but your certification is also on behalf of any affiliates and your first tier subcontractors. So your certification involves certification that you haven't been charged or convicted of the specific list of offenses under Canadian law, but it also extends to and requires you to provide a certification against a charge or conviction of similar charges or convictions from other jurisdictions. So you're not just limited to Canadian-based charges or convictions. The policy actually looks out to other jurisdictions. And because of the link to your affiliates or your subcontractors, you could be suspended or rendered ineligible to bid if your affiliate or your first tier subcontractors have been debarred or have been charged or convicted of the Canadian or the corresponding jurisdiction offenses. So next slide, please, Michael. And the next slide. I think you've seen me enough. There we go. Trends in procurement. We're going to talk about a couple. Let's see, which ones do we want to do first? Okay, so we've got the couple up here on the screen. We're going to talk about the first three today. We may not get to the fourth because I want to leave some time open for questions. We'll see how we go. And as I mentioned earlier, the COVID impact, and we'll talk about in part two, as well as some changes to the Canadian International Trade Tribunal Act, to the regulations and how that can impact bidders. All right, next slide, please. Sorry, I'll take you back one, Michael. Thank you. Okay, so there's a wide variety of programming efforts in progress at PSPC and shared services, some of which have been, as Faye noted earlier, slightly derailed by the influence of the pandemic. I tend to look at these the trends that we're going to talk about in three categories: procurement modernization, social policy influence, and oversight and security. As I mentioned, with the pandemic, we've got a fourth category, COVID impact, and we'll talk about that more in part 2. So as with most government procurements, there's always the desire to streamline the procurement process. We've got 3 current projects that are underway. First, with Shared Services Canada, they're bringing into place the Procure to Pay, or P2P portal. This was launched in 2016, and this portal system is intended to electronically manage the procurement to payment process for selected shared services procurements. So currently, Shared Services is posting its procurement opportunities on the federal site, buyandsell.gc.ca, but for selected opportunities, they are now directing you from buy and sell to the P2P portal in order to complete the bidding process. PSPC has 2 initiatives underway. They're transitioning from buyandsell.gc.ca to a new Canada Buys website, and they're going to be modifying the way that they manage the standard acquisition contract clauses, or the SAC clauses. So the first one is the PSPC. It's an electronic procurement solution, which is going to be the underlying basis for the new Canada Buys website. PSPC began phasing towards this in 2018. And this procurement tool is supposed to be cloud-based, and it's going to help them automate and streamline the procurement process. And I'll just pause here because getting information on this is a little bit difficult because at current process, it's just being explained. However, what we've recently learned, and we're going to be issuing a bulletin on this in the next couple of weeks, and we'll be happy to share it with attendees today, which gives you a bit more detail. But what is currently going now is certain functionalities in the new site are already up and running, including the software applications, and bidders can now register in these applications. The government expects to transition to the Canada Buys in a phased approach, and they're planning to be fully transitioned over by the summer of 2021. So they're transitioning procurement, which I think is a really smart move by commodity group. So as a commodity group is being moved to Canada Buys, then you as someone who might bid on that commodity, you can move over to Canada Buys instead of, you know, a random, this procurement might be there and this one might not be. Currently though, PSPC is making all the tender opportunities available on buy and sell, and some tender opportunities, kind of like the P2P portal at Shared Services, will redirect you over to their platform where you can go through the bidding process. And they did mention yesterday in an in-service that they've had a couple of procurements go through that, and it's actually gone quite well. One thing to keep in mind is that the government supply codes, the GSIN codes, are no longer going to be used, and PSPC is moving towards the United Nations Standard Product and Services Codes as a way of standardizing product references. Once PSPC gets their department purchasing migrated over to Canada Buys, other federal departments and agencies are going to move to this new platform. Ultimately, the intent is, in accordance with Canada's obligations under the Canadian-European Free Trade Agreement, this platform, Canada Buys, is going to be the single point of access for federal procurement. And in fact, as a result of the Canadian-European Union Free Trade Agreement, it will become the single point of access for all federal and sub-central government procurement opportunities, with the plan being this will happen by 2022. Now, with regard to anyone who isn't a federal government purchasing authority, you will start out at the Canada Buys entry point, but then you will move over if you're bidding, for example, on a provincial or a municipal opportunity. You will transition over to that entity's own procurement system. So they will still run their own procurements, but your point of entry to public procurement in Canada will be the Canada Buys website. And finally, one of the other changes that's coming, although again, this is all very preliminary, in the summer, PSPC released a document that provided a conceptual overview of how they're modernizing and simplifying their procurement practices by implementing their standard terms and conditions into the actual solicitation and contract documents, and getting rid of the reference codes that were provided with each of these standard acquisition contract and conditions provisions. So all these SAC provisions are currently publicly accessible and available online in the SAC manual. So that's similar to the FAR and DFAR setup, where you can go online, you can see what the terms and conditions are. Normally, when they're updated or modified, the reference codes that go with each section and with each basket of clauses provides the update of the modification. So as a bidder, you could always check the clauses online to see, have they changed since the last time I bid on an opportunity, and got advice as to what the risk and opportunity was in those clauses. So that's, so far, PSPC has only indicated the new model is going to integrate the clauses directly into the solicitation document, and reference codes are not going to be used. It isn't clear whether the manual itself is going to remain publicly available, or if the information that was provided with the reference code, so the date the clause was last modified, is still going to be available. It's somewhat disconcerting because now, because of what we've seen with Shared Services Canada, they've been moving towards this type of integrated model over the past few years. And to date, they haven't made available any publicly available standard terms and conditions. So there is a concern this new way of doing things may result in a potential loss of openness and transparency and government accountability. But again, we're only in the preliminary stages, and PSPC hasn't really let us know whether there's going to be the public availability of these terms or conditions or not. We already talked about pre-qualification and the two-phase bid review process, so we can go on to the next slide. Social policy and procurement. This is increasing in influence not only in Canada, but worldwide. It's probably not surprising, but social policy is going to influence procurement and is becoming increasingly more important. We're going to talk about how the social policy impact in defense procurement with the industrial and technological benefits policy is impacting defense procurement, and that will be in part 2. But understand that as a government currently, the federal government has committed to programs supporting small businesses, but small business located in Canada, and for identified groups, women, minorities, Indigenous persons, and the disabled. So you're going to start to see this influence within the terms of the contract itself. For example, obligations to consider identified groups in contracting and subcontracting. So the third category, as I mentioned, it's oversight. We've already talked about vendor performance and the integrity and suspension policy, but I did want to mention that there's increasing attention being paid to cybersecurity, security and data protection, not surprising. And you're going to find that you're now going to be subject to more stringent security requirements, including increased requirement for product functionality and security control disclosures that will occur in advance of the products or services you're supplying being accepted by the government buyer. So the intent is to allow greater access to the underlying technology so that the customer can test and understand the cyber threat vulnerabilities. Naturally, this may raise concern with regard to what type of technical data you're being required to disclose and what are the protections associated with this. Next slide. Yeah, we're running up on the end of the presentation. So we are going to move beyond, we're going to skip over the government contracts regulations, but I would note at the bottom of the slide, there is a link to a bulletin that we published when these regulations were changed in 2019, and it explains the impact of the regulations for bidders. So Michael will go on to the next one, please. And the next one. Okay. So after all of this, what are the top 10 takeaways? So first, Government procurement has similar characteristics no matter which side of the border you're on. So it's not just a commercial transaction. It's going to be heavily influenced by policy and politics. So it's just as important in Canada to understand the political landscape as in the US. And Andrew House will be talking more about that in part 2. Second, if you're participating in a procurement, learning how the process works in advance of the process starting is critical. Next slide. Third, as I mentioned, critical thing to remember, in Canada, the bidder retains the obligation to ensure they understand the requirements and to submit a responsive bid under Canadian procurement law, whether you're under the trade agreements or not. This is even more important because, as I mentioned, there's a limited scope of bidder protest options available to bidders. So knowing how to deal with this procurement before you get into it is incredibly important. That's why the fourth point is important, which is take full advantage of the Q&A period. If your bid team or if your bid review team can't appreciate what the essential elements of the procurement requirements are, or if they're saying to themselves, I think this is what it means, or the other one, everyone knows what this means, then you need to be asking questions to find out, what did the government mean? Contracting authorities at the federal level, they expect questions, they're ready for them. And remember, once the bid period closes and your bid is submitted, in Canada, correction of errors or your assumptions is generally not going to happen. Next slide. Fifth, always take a debrief, whether you win or lose. It's really important. If you lost, you need to know why. And if you won, you need to know where you lost points and how to improve your bid for the next time. Because how you won on one bid has no bearing on whether you'll win on the next bid. 6, the timeline for bid protests, as I mentioned, are short and they are strictly enforced. The CITT does not flex on these timelines. So it's important during the solicitation process because the opportunity for bid protests is so short and the timelines are so tight. It's important during the procurement process to retain really good records so that if you want to dispute the solicitation, you have your ready to go file containing all the information you need. Next slide. All right, number 7, the influence of security and supply chain integrity is increasing. So back in the day, doing a 360 review of your own organization filled the bill. It doesn't anymore. You need to be assessing your related companies and your first tier contractors. Number 8, unethical behavior is gaining prominence as an element that is assessed and it can impact bidders and contractors. Unfair advantage, conflict of interest, and collusion are all now fundamental provisions that are assessed during a procurement process, not only federally, but provincially and down through to the municipal level. Number 9, social policy is increasingly influencing how governments buy and what they buy. And finally, government process streamlining is coming. It's important to stay informed and to be ready for the changes. So there we go, Neil. I've done federal procurement in 1,000 easy steps. I'll hand it back to you now in case we have any questions that have come in.
Thank you. We do have a few questions. The first one's for Marcia, and I think this is something that you touched on. The question is, can you launch a protest with the CITT before the contract is awarded?
Absolutely. And again, it harkens back to the element of when did you know or reasonably ought to know you had an opportunity for protest? And I would say, as kind of an aside, it's not something that I see a lot of federal government contractors taking advantage of. I'm not sure what the lack of motivation is there, or whether it's just believing that you need to wait until the contract award has occurred before you protest. But if you are in a procurement situation and you have asked for a modification of the solicitation, or you're not getting the responses that you believe you need to have, then if you believe you have a dispute and if you believe you have a complaint, you can go to the CITT in advance of a contract award.
Thanks very much. The second question that we got also for Marcia, and I know you said that part 2 is going to deal with COVID-19 specific matters, so I'm not sure if you want to give a sneak preview or not. But the question is there a risk that if I receive a sole source contract during the pandemic, it could be canceled?
Okay, that's a good question because there's a couple of elements that come in. So on the general federal government procurement process, the government always reserves what's called a termination for convenient right, which means that they can terminate a contract if indeed they need to do so. A lot of public entities need to retain this right because of funding, because of budgeting related issues. However, if the question is more so, if I got awarded a contract during the pandemic and the government decided they didn't want to have the contract, they could do a termination for convenience, but normally they would carry through with the contract. It's not, unless your contract itself has additional termination rights, the government will normally want to conclude and work through to the end of that contract, particularly because running a public procurement is a time, energy, and resource intensive event. So if they've gone through the process of engaging with you and awarding you a contract, they're not going to willy-nilly decide that they're going to terminate it and, you know, run off in a different direction. If that didn't fully answer the question, by all means, please let us know and we can add some more detail there on Thursday.
Thanks a lot. Next question that we got is for Faye. During the presentation, you mentioned that the key security officer does not need to be Canadian, but is there a preference that the KSO be Canadian?
Right. So there is not really a preference per se that the key security officer be Canadian. The one point I will note, though, is that when the contract security program is conducting clearances for a foreign citizen, it may take longer. This is just due to the fact that they have to contact foreign governments, and in such a case, they don't have the same standard processing times that they know with certainty for the Canadian government, and it's just involving more pieces. So there's no preference, but it's something to be aware of, that it could possibly involve a longer time frame.
Okay, thank you. And the last question again for Faye. You had mentioned remote organizations that do not have a physical office. You talked about that. How does the clearance process work for those types of entities? Right.
So as remote organizations are becoming more and more common, and the contract security program is dealing with this more frequently, it's kind of is not a publicized issue or process, but what we have learned in dealing with this with our clients is that the general rule is that when questions are asked about the entity, such as the registrar's corporate address, that information is used. But when you get to the specifics of this employee is working in this place, and say that employee is the key security officer, you provide the information for that location. So it is the same, it is based on the same process. It's just the specific information that you're providing in the forms that the program asks for that may involve a bit more thinking and ensuring that it's the right information. So what we've done often in this case is make calls or emails to the contract security program on behalf of our client on a no-name basis to figure out what they're looking for, because sometimes it's not always obvious with these unique remote situations. But as the base, it is essentially the same process. So back to you.
Great, thank you. That covers the questions for today. So we wanted to thank everyone very much for participating, and we look forward to part 2 of the seminar in a couple of days.